Like any other lawsuit, a complaint is filed and a defendant needs to file a formal answer. Typically, the complaint is mostly boilerplate in a preference case, and so is the answer. The defendant may also choose to file a motion to dismiss the case on various grounds. In fraudulent conveyance litigation, the complaint must be more detailed because generally fraud is being alleged, so motions to dismiss vague complaints are a lot more common than in preference cases. The answer in fraudulent conveyance cases must also be more detailed than specific. After the answer is filed, typically the next thing that happens is a status conference, during which the bankruptcy judge will set out the relevant deadlines in the case. The status conference usually takes place about 30 days after the answer is filed. Since the trustee is usually suing a number of different defendants, the judge will usually not go into the facts of any particular case or any substantive issues for a particular defendant during the status conference. In the Enron case, over 5,000 cases were filed. It's not unusual to have 200 or 300 cases filed at the same time. The status conference will set a deadline for discovery, expert reports, and other matters. After the deadlines have been set, typically discovery starts immediately. Usually, discovery lasts 3 to 6 months. After discovery is over, one or more of the parties may file a so-called dispositive motion. These motions ask the judge to rule on the case without a trial. The theory is that there are no real facts in dispute, and so the judge does not need to see and hear testimony, live testimony, and judge the credibility of any particular witness. There are not really any facts to decide. These motions, these summary judgment motions, usually take a couple of months to be filed and heard. If those motions don't resolve the case, the judge then might set the case for mediation or set a deadline for trial. Trial is usually scheduled 2 or 3 months after the deadline for dispositive motions. Usually, there's motion practice before trial. For example, one of the parties may want to prohibit the judge, if the judge is the trial of fact, could be a jury, from hearing certain kinds of evidence. After the trial, there may be post-trial briefs. After those, the court will issue a ruling. 99%, actually more than 99% of cases are settled by negotiation at mediation, or resolved through motions for summary judgment, or resolved by settlement negotiations that take place during the case. If the case is not resolved and goes all the way to trial, the time frame is usually about a year from the start of the case before resolution.